Hello, you're on live with Hornbill TV. The Supreme Court, while hearing the contempt proceeding in connection with Nagaland government's decision to cancel the urban local body elections in the state, has stated on Monday that the affidavit breaches the order of the court and that the order cannot be evaded. The apex court also said nothing has so far emerged, advancing the views that the practices of Nagas is being interfered with by the emancipation of women through reservation. The SC bench told the Attorney General that he cannot let a part of the country escape the Constitution scheme. The next hearing has been listed on May 1st. Meanwhile, Nagaland Chief Minister Nefurio has on Saturday said that the state government will hold a meeting with all the stakeholders to discuss the issue and make a concrete decision. Well, today on live, we are joined by our associate editor, Alan Woolley, and today we'll be talking about the recent SC hearing on the ULB polls that was supposed to be held on May 16th, and also what the ramifications could be for the state government in case the SC finds that it has breached contempt on court order, and also what could be the way ahead for the Nagaland government too when it comes to ULB polls. So we'll be having a discussion on this matter. So, sir, just to give you a little chronology over what has happened over the ULB elections, I mean from the date when the SC pulled up the state of Nagaland. So, it was on July 14, 2022 when the Supreme Court first pulled up Nagaland, particularly for the holding of the urban local bodies election. And then on July 29, 2022, the SC had told, had asked the state government that they should hold the polls by at least January of 2023, but then the state government had given some excuses in which the Supreme Court had stated that 12 years have gone by and still there is no ULB elections. Then the next hearing, the major decision came on May 9th, 10th when the government of Nagaland, the newly instated government of Nagaland, had put out a date that on May 16th the ULB polls would then be held. But then there was a large hue and cry. And then on March 14th, after the government of Nagaland had actually decided on the polling day, which was May 16th, the SC then again put a petition in which it said that the date and the ULB elections in Nagaland should not be disturbed. But then by the time the civil society organizations already started opposing, and on March 29th, the Nagaland Legislative Assembly passed a resolution in which they cancelled the ULB and also repealed the NMA Act of 2001. Then on April 5th, which is a few days back, the Supreme Court had stayed the order for the cancellation of the Nagaland ULB polls 2023, and today the Supreme Court had told the state of Nagaland that the affidavit submitted by the state of Nagaland could be considered as breach of contempt or of court order. So, sir, what is the way forward? And also, I mean, like the Supreme Court has mentioned that there can't be an exemption to a state when the scheme is already enshrined in the Constitution. So, sir, what's the way forward, and is there any exemption to a scheme that has already been scripted in the Constitution or enshrined in the Constitution, sir?
Yeah, Akivi, we were discussing about this earlier, that the Supreme Court of India will sooner or later come over and knock down our doors because we did something that was, of course, Article 14 is there, right to equality and equal protection under the law, and we have 18 and 19 too, which says that which gives equality to everyone, men or women. Yeah, when we're talking about the 33% reservation of seat for women, we are talking about a right that is not necessarily connected with practices of a certain community, of a state or a region here. We are talking about a right that is given itself in the Constitution of India. So that is the reason why we were discussing earlier that right after the government of Nagaland repealed the Nagaland Municipal Act, and with it, effectively, the 33% reservation of seat for women, the court will come calling, because when we're talking of equality, we are not talking of just a small aspect of representation in a policy-making body here. That is the municipal councils. We are talking about the right that is effective not only to a singular man or a singular woman. It is talking about the equality of a community in general. So the way forward here is, I think the government of Nagaland will have to sit out the contempt proceedings here, and it will be very interesting to see how the arguments will play out and how the perspective of the Supreme Court of India will affect the verdict that will be given in regard to the government repealing the law. So right now we can only say let's wait and watch for the court to take this process and complete it, and let's wait for what it has to say, because only then the government of Nagaland interestingly is sitting in a contempt proceeding. So only then we will know what the government of Nagaland will do in this regard. Akive.
All right, so on March 10th, there was a ray of optimism because the then newly instated government had already set a date of May 16th that the ULB polls would be held. But then after that decision to hold the polls on May 16th, there was a hue and cry over the decision to hold the polls by various civil society organizations. So, sir, I mean, basically in simple terms, what were some major bones of contention for holding a ULB polls only in Nagaland?
Akive, I think the grounds on which the community organizations have been opposing the urban local body elections based on the caveat of 33% reservation for women is basically the same set of arguments that they have been using over the past several years. 2014, and again we have 2018, and then in 2017 there was a lot of violence. So even during these occasions, they have raised opposition to the reservation of seat for women has always been the same. First, initially it was just the 33% reservation for women. And then second came the whole concept of taxes. So nothing has changed if you really look at the order of things that have happened in the past 15 years. Nothing has changed in regard to the arguments that the community organizations have been making in this regard. So I don't think there is any kind of a new argument that the organizations are taking in this regard, because like I said, they have been repeating the same statements. That is the opposition to the seat sharing or seat quota that has been given to women. It has always consistently been the same argument over and over again. So first thing is taxes, and the government of Nagaland has said they have already removed the rider where it says that we will be giving taxes on buildings. And then second, the demand was that the 33% quota should be ratified, which again the government said that was something we cannot do, because the government, the Supreme Court of India has already demanded that the seat be instated. There be no changes in it. So that was the reason why, although the government of Nagaland had already conceded to all the demands of the community organizations in regard to the NMA, the only part that the government could not concede to was the reservation of seat for women. So that was the reason why it compelled the government to remove it entirely, so that we wouldn't be having this conflict. But of course, the Nagaland government did not foresee that the Supreme Court will come asking questions. So that is the situation right now. So basically what we have here, after the rider of taxation had been removed, it's only the reservation of seat for women, based on which the community organizations don't want the municipal elections to take place.
All right. Also, so over the past few days, where we have heard various CSOs gratifying and justifying as to why the ULB shouldn't be held, is one of them is protection of our Naga rights, which have been enshrined in the Constitution through 371A. But then the Supreme Court today has said that it does not see any discussions in which it sees itself interfering in the practices of Nagas, and also that the 74th Amendment, which talks about municipalities, it does not actually have to do anything with 371A, as it falls on the towns and municipality jurisdiction. So, sir, where is this argument coming out from, and does this ULB actually infringe upon a Naga's right, sir?
Yeah, okay, that is an interesting but a complicated question for us to answer, because this is an issue that demands more than just an opinion of a layperson, or even from the anthropological point of view also. To be fair to the judiciary, and with due respect, the courts do not know how the ethos of the Naga people work. So only us, we know what is going on at the ground level. But then again, to be fair to the courts also, they are looking, I believe, from the point of view of equality, which has already been enshrined in the Constitution of India. And in this particular context, we are not talking about a particular community or their practices, their personal laws, or how they live their lives. In their villages, in their family, how they govern their personal relationships, how they govern their social lives with rules and regulation that is based on the lore of ancestors. We cannot expect the judiciary or people from Delhi or Kerala to know the kind of lives that we live and the kind of rules that bind us towards an allegiance to our community beliefs. So to be fair to the Supreme Court also, they might not really be fully understanding this context, especially in the context of the Naga people. But what they are doing, I believe the judiciary and the Constitution of India is already there. They are looking at it from the perspective of equality as a right, equality again on the part of the community, equality as a duty. So these are topics, these are concepts of human existence, especially within social frameworks that are supposed to be implemented and respected and honored and used in the way that the Constitution of India envisages us to use and to implement and to comply with. So I believe that the Supreme Court of India and judiciary in general, they are looking at the Constitution as a tool, not as a weapon, but as a tool to bring about the kind of rights and the equality which the Constitution of India has already given to every one of us, whether you are a Meitei, you are a Naga, you are Bihari, or from Kerala. It doesn't matter. So what the court is saying here is that as long as it is for the good, and the right of equality has already been enshrined in the Constitution of India, and as long as it is something that will give you progress to move you forward, as long as it's a positive thing, I think this can be implemented by everyone and used positively, no matter what your customs are. That is first thing. Second thing is, and looking at the whole issue from the point of a Naga person, from the point of view of a Naga person, we are talking about Article 371, which says that no act of the Parliament will have to infringe on the customs and the laws and customary practices of the Naga people. So we are not really looking at the judiciary's point of view. We're looking at it from our point of view, which is our cultural practices. So we are using this argument to make sure that our way of life is preserved. So this is a constant argument that keeps coming up. So like I said, it will be interesting how the two point of views will have to reconcile with each other if we are to move ahead with the whole question of holding elections to the municipal councils. Akivi.
All right, so we'll be speaking more on the Naga Mothers Association and also actually what could be the impacts of holding a ULB poll in Nagaland, but after a short break. But to all the viewers, today's discussion on live is about the recent decision of the Supreme Court that heard the Nagaland's decision to cancel the ULB polls that was supposed to be held on May 16th, in which today the Supreme Court has said that the affidavit submitted by the government of Nagaland could be considered as a breach of court order, and that the Supreme Court has also listed the next date of hearing to May 1st. Through our associate editor, we've come to understand a bit as to why this contentious ULB issue is popping up all the time. That too when it is supposed to be held in Nagaland, and there we had a little insight as to how there is a point of view through the judiciary, and also there is a point of view from the Naga perspective, and that there are clashes in certain areas in which Nagas are fighting for the preservation of our own unique rights. And as for the courts, it's more about to do with equality. Well, coming back, we'll speak more on the Naga Mothers Association and also what impacts could the urban local body elections actually have in Nagaland, and whether it could be another form of government that could also ease the load on the government agencies that are practically running, and also it could be a more decentralized form of a government. We were speaking on the Supreme Court's decision on the urban local body polls that is to be held in Nagaland, and how the Nagaland government had cancelled the ULB elections that were supposed to be held on May 16th, in which the Supreme Court of India had stayed the order on April 5th, after which the hearing was today, in which the court had said that the government of Nagaland, through its affidavit, it could be considered as a breach of court order, and they have stated that the next date of hearing would be May 1st. Well, in the initial part of the discussion with our associate editor Al, we heard about the various aspects of why this issue is quite the controversial one, and in which where we've seen in Nagaland over the past few days how various civil society organizations, tribal apex organizations have called on unanimously, stating that there should be more discussions on the new municipal act, and that also on the other hand, the Supreme Court also pushing the government to hold the ULB as it has not been held for 12 years. Now, continuing the conversation with our associate editor Al. All right, sir. Now I want to shift our focus to the Naga Mothers Association. I mean, Naga Mothers Association at one point of time was considered to be a very important and strong organization. They were also one of the few important bodies responsible in bringing the Nagaland Total Liquor Prohibition Act into Nagaland, along with various other bodies. And after the decision that after March 10th, in which the Nagaland Assembly cancelled, it was on March 29 when the NLA had cancelled the ULB polls, they were still fighting for the 33% reservation, after which they received a backlash from various tribal organizations, in which various tribal like the Angami Public, Chakasang, the Sumi, they have all stated that they should dissociate themselves with the NMA because of its unmandated body. So what are the reasons? How come an organization that was so adored and respected today is not getting the same kind of respect and adoration?
Kivi, I think there's a question. If we really have to answer, it will bring us a lot of problems.
just to make it a little less controversial. What are some of the reasons that the tribal organizations have stated to their respective organizations as to why they should dissociate themselves with the NMA?
Okay, we'll just go over some of the more politically acceptable reasons that we know that the community organizations in Nagaland have been really opposing the NMA right now. So like you said, the Naga Mothers Association was one of the most beloved community organizations in Nagaland. They were there even during the 80s, during the height of political violence between the Indian military agencies and the Naga armed groups. They were the first one to go in brokering peace everywhere, Akivi. I think you might have come across a movement called the Shed No Blood movement. So they were the people who stepped in between the Indian military and the Naga armed groups during the clashes those days. And when I say clashes those days, it was practically every day. And the Naga Mothers Association was there every time something happened. And then, of course, came during the early 90s too. They were very vocal about alcohol, the sale of alcohol in Nagaland. And I believe that even till around 10 years ago, they were, I believe, the bulwark that really held together the whole narrative of keeping Nagaland free from alcohol. So in that way, the generations before us, they really adored and respected the NMA because of the moral stance and the posturing it took on this important issue. But like you said, times are changing now. the people who used to be there forming the leadership of the community, they are slowly disappearing. The generation that used to respect some of the organizations that represented the Naga community, they are all disappearing. And young people are coming up and they don't know who the Naga Ho'o is anymore, who the NMA is anymore. And that is another reason why it is easier for people to, follow the crowd when it comes to community criticisms, when it comes to important leadership organizations that take positions on certain issues. So the first reason here is that a lot of people don't know the NMA. That is, and I'm not talking about just young people. I'm talking about people who used to be there when the NMA used to be a really strong voice in some of the most pressing problems facing the Naga people and the state of Nagaland those days. That is the first one. Second thing, I think the whole narrative of organizations like the Naga Ho'o and the NMA, and of course we were talking about this earlier to Akivi, the Naga Movement for Human Rights, the Naga People's Movement for Human Rights, the organization, these are three organizations that have constantly been accused of being biased, being partial, while other armed Naga groups were neglected. Their issues were not taken care of or given a platform by the three organizations, Naga Ho'o, NMA, and the NPMHR. So that might be another reason what led to the kind of division that we're seeing today among the public. Some are saying Naga Ho'o, we should keep them, NMA, we should keep them, but there are people who are saying now, let's stick with the Central Naga Students Organizations, Central Naga Tribal Organization, the Naga Tribes Council. So there is so much polarization in the community because I think the leadership, the vanguard that used to be the face of the Naga people outside is no more the organization they used to be. And then that will be the second reason, I believe. And the third reason, I think, earlier we were talking about how a certain person in the organization seemed to be the only person that has been leading the NMA for a long time. You know, we don't see that many new faces, we don't see new ideas. So that might be another reason why people are using this whole issue of reservation of seats for women to go against the NMA and to somehow, subdue it. So I believe those are the three reasons. Others, so like I said, I cannot talk about it. Yeah, not on TV.
All right, so thank you so much for joining us on this newsroom and giving us a little more details as to why the ULB issue is very contentious in Nagaland, and also what could be the further ramifications, what could be the state of government's move in the next coming months. And also on May 1st, the Supreme Court has asked for its next hearing. So it will be, thank you for giving us the details. Now we know what to look forward to. Thank you so much.
Thank you, Akibi.
So that was our associate editor, Alanguli, and well, he just told us the various aspects as to why the ULB is a very contentious issue here in Nagaland. Well, in 2017, there was supposed to be a ULB poll, but it was violence marred. 2 people lost their lives. Ever since, there has been no election. Like the Supreme Court, and I quote one of the judges in the court, it's 12 years have gone by and there have been no ULB polls in Nagaland. So basically, that is quite a shock story, but that is the truth that is currently happening. But yes, now that the state government has said that it will hold talks with all the stakeholders and decide on the new municipal act, and also there will be more discussions as to whether portions of the municipal act or even the 74th amendment, if it actually infringes on the unique rights that Nagas have. So there will be further discussions, there will be professional studies done by the legal experts. So I guess it's just a waiting game now, and on May 1st, whether the state government or Nagaland government will actually give a valid explanation to the Supreme Court, and whether the Supreme Court would also accept or also validate the affidavit given. As the hearing done today by the Supreme Court has said that the affidavit given by the state government could be considered to be a breach of court order. So, on May 1st, it will be safe to say if the Supreme Court actually listens to the general reasons the state government gives to the Supreme Court. Well, this was all for this hour's bulletin. For more news and updates, stay tuned to Hornbill TV. Goodbye.